real property, contracts, remedies, three-way crossover from July of 1982 is an enormously useful fact pattern for us to review, despite the fact that this is about the oldest fact pattern that I use, and in fact, it may be an essay question that is older than some of my students. Still, it's quite useful. Have a look with me at the call of the question. What rights does Andrew have, and to what relief, if any, is he entitled? 1. Against Barry. Discuss. 2. Against Charlie. Discuss. Well, we know how to outline this fact pattern before we read it, and that's a good thing, because it turns out to be a pretty complicated pattern. For each of these lawsuits, Andrew versus Barry and Andrew versus Charlie, the plaintiff is going to have one or more theories of liability, and we're going to go into each of these theories in great depth, in the same format that we used back when we were considering the substantive law of torts and contracts and property. We will also think in our minds about a prayer for relief, and we know that remedies includes damages, restitution, and equitable relief. So we've spent about 30 seconds looking at this call of the question, and already we can outline our basic answer to this fact pattern without even looking at the actual details. And as we get into those details, we'll see there are a fair amount of subtleties, and a couple of different bodies of substantive law are being tested. Look at paragraph 1. Here we meet Andrew and Barry, our plaintiff and our first defendant. They have adjacent lots, each fronting a busy road. They're getting ready to make a partnership to construct a building, but they never made a deal. Okay, fair enough. Paragraph 1 is background. In paragraph 2, in January 1981, Andrew sends a letter to Barry. Keep in mind, this is a 1982 fact pattern, so the events of January 81 are recent. So, Andrew sends Barry this letter saying he's going to build a building on his own, on his lot, and he wants to use Barry's lot for customer parking for 5 years, should the restaurant be successful for that period. That's an offer. It looks like a valid offer. It looks like a common law governed offer. And then we look at paragraph 3. On receipt, Barry glanced at the letter and assumed it was for a partnership agreement. He wrote on the letter, "Okay with me," signed his initials, and mailed it back. That looks like an acceptance by a party who was not paying attention. So, to me, this looks like a binding contract, even though Barry's not paying attention. We move on to paragraph 4 and look at what happens. Andrew builds a big restaurant on his lot. He spends a lot of money doing it. And he spends a bunch of additional money and time on Barry's lot also to turn it into a proper car parking lot. Then we see the restaurant opening in October. Cars fill the lot on evenings, and one such car belongs to Charlie, our second named defendant. Charlie is a regular customer at the restaurant, and in early December, Charlie buys the lot and the improvements from Barry and fences the parking lot. And now he won't let Andrew use it for restaurant parking. And after that, Charlie returned Andrew's payment checks uncashed. And we get the question about rights and remedies of Andrew versus Barry and Andrew versus Charlie. A very interesting fact pattern. So, Andrew versus Barry is going to be a litigation over contracts. Andrew versus Charlie is going to be both a contract and a real property analysis. It's a little complicated. So have a look at the outline of issues that I've presented, and you'll see, although I'm not doing anything new, I'm not doing anything different than what I was doing way back when we were studying contracts and real property, you'll see, as an approach to a question like this, it's enormously useful. Okay, Andrew is suing Barry over a breach of contract, so we deal with contract formation. There's a couple of facts in there we have to handle. Defenses to formation. 1, the defendant didn't read the letter he signed, and 2, could the contract be deemed illusory given the language in it about making the contract conditional on the success of the restaurant? The breach of the agreement is established by Andrew's sale of the lot to Charlie, and with regard to remedies, since Charlie is now the owner of the parcel, the only remedy that Andrew can get from Barry is damages. And you'll see when we get to the answer, I go into that damages issue in a little bit of depth. Next, we turn to Andrew versus Charlie. This is by far the more difficult part of the question because it requires us to consider real property issues. We talk about a lease, an easement, a license, and then with regard to Andrew's lawsuit against Charlie, we think about the whole panoply of remedies, damages, restitution, and the preferred remedy in this case, equitable relief. And you'll notice in the outline, I do not break equitable relief up into its many elements, and you'll see in the answer, again, I don't do that. I squish all of it into one big paragraph. And the reason is, this is such a complex problem. I don't think it's really a remedies problem as far as equitable relief goes. They aren't testing our knowledge of the elements. They're testing our knowledge of the applicability of this remedy to complicated facts. So I choose to put more of my attention into the earlier sections and to give equitable relief the minimum that I think I can in order to cover it properly. If you had the time to break it up into greater detail and cover everything, I think that's great. You've got nothing to worry about. So now let's take a brief look at my answer, and I'll show you a few highlights that I think are worth your attention. Notice up front with regard to Andrew versus Barry, I state what Andrew has to establish in order to be entitled to remedies. Then we get into the contract. And the paragraphs on formation and defenses to formation, I think, are pretty simple. And the issues presented also are quite simple. But once again, notice how I find a home for the facts and how I don't allow the law or the facts to totally dominate the discussion. Keep in mind, the points live where the law and the facts touch one another. And I think these paragraphs about the contract formation are examples of those skills being put to good use. Next, we turn to the breach. A simple element, the sale of the element to Charlie and Charlie's fencing of the lot, constitute a breach of the agreement between Andrew and Barry. Next, we focus on remedies, and here, specific performance isn't available because the decree is no longer feasible. Barry's no longer got title. So Andrew is limited to contracts damages based on lost revenue caused by no parking, less the $250 in rent that Andrew is saving. And if Andrew can get substitute performance, he would be entitled to recover any amount above the rental amount that he is obligated under the agreement. Also, it's worth mentioning that Andrew could recover the expense that he spent in improving Barry's lot. There's no reason for Barry to be unjustly enriched, and so Andrew can get a restitutionary recovery also. But remember, that restitutionary recovery also would be a dollar remedy that could be enforced like any other money judgment. So Andrew recovers money against Barry, but he does so both under a damages theory and under a restitutionary theory. So really, with regard to Andrew versus Barry, I have covered all of the possible remedies: damages, restitution, and equity. Next, we move on to consider Andrew versus Charlie, and here I lead with the key fact up front. There's no privity of contract between Andrew and Charlie, so Andrew can't sue Charlie under the agreement. The only way that Andrew can seek any kind of remedies against Charlie is through real property law, and the remedies available will depend on the type of agreement that Andrew had with Barry. And the agreement is silent as to exactly what the agreement is. We know what the deal is. It was a lease, an easement, or a license. That's what really we're looking at. I think it looks most like a lease, and that's why I use the lease analysis first. I think that's the best way to characterize this agreement. And as a result, I would give Andrew an interest in the lot that Charlie would take subject to. And the only defense that Charlie has is to claim protection under the Recording Act because we have an unrecorded conveyance, a lease, and Charlie paid value. But Charlie's problem is he has actual knowledge of Andrew's use of this lot because Charlie's a regular patron at the restaurant, and it's not reasonable to allow Charlie to claim ignorance as to Andrew's interest in this lot. Next, we consider a slightly less helpful theory for Andrew, and that's an easement. I think it's a little less helpful because a lease gives a leaseholder a stronger interest than an easement does. And An easement is best characterized where the user's use of the property is non-exclusive. And here, even if the interest that Andrew acquired through this agreement with Barry was a mere easement, Charlie still would take the lot subject to that easement. And again, Charlie's got actual notice of Andrew's use of this lot. Now, the last possible way to characterize the Andrew-Barry agreement is to call it a license. And that's a different interest and much more favorable to the landowner, because a license can be revoked freely. Except here, the fact that Andrew improved the lot at his own expense might be enough to turn this license into a so-called executed license. An executed license no longer can be freely revoked. And in terms of its actual impact, an executed license begins to look very much like an easement. The bottom line is Charlie is going to be liable to Andrew. So, for what will Charlie be liable? Well, we focus on damages, and here it's a one-liner. I guess maybe I find a way to make it take 2 lines. But basically, Andrew is liable for damages exactly to the same extent that Barry is. With regard to restitution, again, Andrew is entitled to get his improvements back, the value he spent on those improvements back, from Charlie. There's no reason to allow either Barry or Charlie to be unjustly enriched by Andrew's reliance and Andrew's making improvements on this lot. Next, we turn to equitable relief. Clearly, this is what Andrew wants, because he wants his patrons to be able to park in a parking lot that's right next to the restaurant. And I focus on the elements, although I don't break it down into an element-by-element paragraph series. This is a dispute about the use of real property. All parcels of real property are unique, and so legal damages are inadequate to a plaintiff in Andrew's position. An equitable decree here would be feasible. Plus, Charlie has acted with obvious bad faith. He's tried to get something for nothing, or at least at a steep discount, and he's got unclean hands. Charlie doesn't have valid defenses to equitable relief. The bottom line, Andrew wins his injunction, and he will get to use this lot for restaurant parking. So, it's a complicated crossover question, but it's crossing over civil liability theories, torts, contracts, real property, and remedies. These are the heart of every bar examination and every California bar exam.